Family, I just want you to listen to this. I'm not too sure what Ratha was really trying to do with this message that has got a million questions, talking about people he has convicted and talking about they bring appeal after 12 years and sometimes they abandon it. Was he supposed to say this? Was he telling us that he has already written the judgment? What was he trying to say? Because you cannot be proceeding with a case of this magnitude and you talk like this. Because ukusho ukuthi uRatha uthi labantu laba abalaphana uzabagweba intambo udilika jele yiko asitshela ngo-12 years ukuthi bantu baletha ama-appeal after 12 years. Uthini uRatha ngempela? What message was he trying to send to us? And after this clip, we will see the braveness of MNISI that he is really fit for this job to take on accused number 1 and stand tall. Let's listen.
1998. So these people, when they saw me coming here, they lodged the 2 appeals. And then they did an application for condonation, which is very funny. Guys would say I have wrongly convicted them. They only appeal after 12 years. But for some reason, then they abandoned those appeals. So I was looking for those files. At least Arthur here found them. Okay.
Maybe I did not get your answer, Brigadier, and there is nothing wrong in me requesting you to repeat your answer. There's definitely nothing wrong in requesting a witness to kindly repeat your answer.
My Lord, the essence of my response was that there was no decision taken. Insofar as the sharing of the narrative, my understanding, and this is how I've been dealing with the NPA from time memorial, you conduct investigation as a police officer, you present the evidence to them. They decide as to whether to enroll the matter or not. And then if there is a need for further investigation, such will be communicated. And I've testified about this, my Lord. So I'm not so sure if I can take it further than this insofar as what the advocates, because I can't get into their mind. What I know is what I presented to them and the responses that I've got, my Lord.
Akuzange kube nesinqumo esathathwa ukuthi sonke sizobona kanje. Futhi ke mithina ke umsebenzi wethu ukuthi kwakuphenya sithole sikutholayo ebese sidlulisela kubona kube yibona ke abathatha isinqumo sokuthi lolu daba lolu bayadlulisela inkantolo. Uma ukuthi khona obunye uphenyo abalidingayo, yebo sasikwazi ukuqhubeka kanjalo kodwa akukho okunye engakuchaza ukuya phambili ngalokho.
Thank you, Brigadier. Let us embark upon a standard 3 approach. Was it part of the prosecutors who were assisting you? Was it part of their narrative that accused number 1 is involved in the commission of this case?
There's a standard 3 approach. We submit, my Lord, that the court has referred to the case of
that case I gave
Azaf, and we
here's a brigadier.
Yes.
It's being referred to as a standard 3.
Yes, and
you must approach him like a standard 3.
No, with due respect.
Okay, I'm not going to argue that point. That's how I view it.
Yes, but my Lord,
let's resort to a standard 3 approach.
No, I am saying, let me take it step by step so that we understand each other. But I'm not saying that the brigadier is a standard 3, my Lord. I would not have intended to say that. I am saying, let us simplify my question in the following sense. Brigadier, let me put it this way. Let me simplify my question. Let's not make meat out of the fact that let us not make a mountain out of the ant small that I said let us have a standard 3 approach. But what I intended to convey to you is that let us take it step by step. Maybe language is failing me. Thank you, Brigadier. But if you feel a little bit disrespected my apology in that regard. Thank you.
Understood.
Thank you. Let us take it step by step. Now, was it part of the narrative of the team of prosecutors who assisted you that accused number one is complicit in this case?
Futhi kwaku umbono wo beshushisi bonke abanamsizana nabo ukuthi umsola uqala naye ke wayethinteka kulolu daba.
My lord, accused number one has been charged. What is the relevance of that question?
I understand accused number one was charged, but was it part of their narrative that accused number one is complicit in this case? Yes or no?
Funa ukwazi ukuthi ke kwakuyindlela ababona ngayo yena ukuthi ke umsola uqala naye wayethinteka kulolu daba.
My lord, perhaps you assist or answer this way.
Yes.
All the accused, 1 up to 5, when the memorandum was taken to the DPP, there was a decision to indict all of them on the charges, on the 5 charges that are before court. Despite the indictment, that decision was taken. Insofar as Ms. Kulu Kumalo, further instructions were given for me to do. And that is why the statement I read here in court, where I was directed by Mr. Ramsipili, stated the date of November 2014. It was part of those further instructions to say, follow these instructions and then bring it back. And then subsequent to that, then the warrant was not signed. But there was never an objection to say we should not pursue this. I don't know if it will assist, but I will not be able to quote word for word as we're sitting there what the advocates were saying. But there was a desire to say, let us get more evidence to connect. Hence I said, my lord, before this accused appeared in October, we had some evidence against Ms. Kumalo, which I've explained in this court. Later in November, we had more. We even dealt with the cell phone numbers. That was part of the procedural driven investigation. So there was a working together between myself and the prosecution. But insofar as the ultimate decision to prosecute, my lord, that lies in the hands of the NPA. And I think it will be dangerous for me to venture into that area as to what informed them. But there was a working together in terms of what should be done with regard to the evidence or the pointers that implicates Ms. Kelly Kumalo.
Isinqumo esaphuma sokuthi ke umsolo oqala kuyofika kwesihlanu bangathweswa amacala, kodwa ke akuzange kuphume incwadi ephuma kwa-DNA echaza ukuthi ke kufanele kusetshenzwe kanje, kodwa ke kwaphuma ke enye ke instruction evela eyalethwa kumina mayelana noKelly Khumalo. Kodwa ke into eyikhona nje ukuthi sasifanele siqhubekele phambili senze umsebenzi wethu. And ke isinqumo ke esavela ko-prosecutor esasivela ku-NPA, and thina sasisebenzisana nokuthi sizame ukuthi sithole ubufakazi obungasiza ukuthi sizwisise kahle indaba kaKelly Khumalo.
Yes, my lord.
I'm still struggling to get my answer on whether or not the fact that Kelly Khumalo is a kingpin in the matter of Senzo Meyiwa was part of the narrative that the team of prosecutors, actually let me not say the team of prosecutors, but the office of the DPP Pretoria had when they decided on this matter. I haven't received my answer, and I don't know what is the difficulty in saying, yeah, no, DPP Pretoria was of the view that Kelly was a kingpin in this case. However, she could not be charged because of this and this and this. That would have sounded better. But to simply decide not to answer my question, clouding it with a whole lot of lengthy explanation, I really don't think that assists in the court. But nonetheless, I realize that is an objection from my colleague.
As a court, please, my lord, and we don't want to belabor this point. The witness is clear that the discretion to charge lies with the Director of Public Prosecution. He presented a memo, and this is the decision was taken by the Director of Public Prosecutions. He cannot take it any further. He said, he cannot, as he put it, go into the minds of, the Office of the Director of Public Prosecutions. I think my learned friend will unfortunately have to live with that answer.
Unfortunately, I am not prepared to live with that answer, but I do realize that it's a very difficult one. But nonetheless, let me proceed. The reason why I am asking this, it's because in terms of the law, when a person gets indicted at the High Court, in terms of Section 144 of the Criminal Procedure Act, the state must inform the court the facts upon which they are basing their allegations against those that they've indicted before court. That is law, which is the reason why I am asking you that question. Do you understand?
Section 104 umthetho ukuthi umshushisi ufanele ayitshele inkantolo ukuthi yini indaba befuna ukuthi bathwese umuntu amacala futhi basebenzise ziphi izathu.
My Lord, I understand. However, and I go back again, my part as an investigating officer, and exactly that, my Lord, was done in the matter. It's a question of separation of powers, and I've explained this, my Lord. The docket was taken to the DPP, as is normally done, for a decision. A decision was taken. Now, for me, my Lord, it's not a difficulty, but I can't speak on behalf of the NPA. It's separated, my Lord. I did my part. I produced the evidence that we had insofar as this accused and what pointed to Ms. Kelly Kumalo. It's a normal, that's how it's done, my Lord. You present it to the NPA, then they will communicate their decision to you as they've done in this instance. Now, I'm not sure, my Lord, how do I then speak on behalf of them? I think the NPA in this situation, my Lord, are better vested with the knowledge of giving Mr. Advocate MNISI the answers that he seek, because I can't speak on their behalf, my Lord.
Mina-ke indlela engizwisisa ngayo ukuthi umsebenzi wethu ukuthi umuntu ophenyayo siyaphenya thina and mase siqedile ngale sithatha le docket sidisa kwa-DPP uyena uzothatha isinqumo sokuthi uqhubeka kanjani. Angikwazi ukubakhulumela abaka-NPA ngoba thina owethu umsebenzi phela ukuphenya base siphenyile bese sidlulisela aba-DPP ibona abathatha isinqumo and futhi angikwazi ukuthi ngibakhulumele ibona abangasikhulumela ukuthi indaba ethatha isinqumo esinje.
Same with the section or the law that Advocate MNISI referred me to. I'm not sure, my Lord, how best can I assist him there. I mean, that lies between him and I think the court and with greatest respect, the advocate, my lawyer, because what do I say, my Lord? That's not my terrain as well.
Futhi-ke nangumthetho kuyafana nalapha kukho mina engingakwazi ukusho ngoba akuyona into engathi ngifanele ngingenelele leyo angayikhuluma mhlambe-ke no-advocate baloyi kodwa mina ngikwazi ukuyingena leyo ngoba akuyona indawo engisebenzela kuyona.
Yes, my Lord.
Now, you're mentioning that you investigated the docket, you gathered all the evidence and presented it to the state. Now, was it part of your, before I get to there, and then after submitting that document, then the state went on to make a decision to charge the 5 accused persons that are before court here, and they gave you instructions to go and issue out warrants of arrest against them, not so?
Manje-ke emva kokuthi-ke uze uphenyo lwakho wathatha-ke le case wayisa-ke abashushisi bayibheka-ke base bethatha isinqumo sokuthi-ke bayaqhubeka nokuthi babathwese icala and emva kwaloko-ke istate-ke sesesibuya-ke sithi-ke sebengashashwa bangakhishwa-ke namawarrant ukuthi bangaboshwa labantu kanjani.
My lord, the first part is correct. A decision was taken and then an indictment was sent to me. I'm not sure if there was instructions to say go and get warrants of arrest. I mean, as I've said before, my lord, J50s are a way of bringing the accused persons before court because a decision was already taken that, they're indicted for these charges. I then took that route, my lord, of applying for J50s as per the affidavit that I disposed, and then that was solely granted, my lord, and then the accused were brought before court.
Kuyiko kodwa ke okwesibili akunjani ngoba zange kube namawarrant of arrest noma incwadi zokubopha ezakhe. Thina-ke esacela nje ukuthi sicela ama-J50 ngoba iwona esawasenzisa ukuthi abantu abalethwe enkantolo njengoba ngishilo kwa-affidavit yami.
Thank you, Brigadier. Part of the instructions in that indictment was that they should be arraigned for trial in the High Court.
Futhi-ke isaphambili lokho ukuthi kwathiwa abayiswe abahambe-ke beyovela enkantolo ephakeme.
I suppose, my lord, I'm just not sure word for word now because I'll have to go through to the indictment, my lord. But I suppose if Advocate MNISI saw it recently, I will not dispute that.
Ngisekela uma ukuthi u-Advocate MNISI akudala ekubonile anginaso isiqiniseko sokuthi kunjalo kodwa kufanele ngibheke.
Yes, that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Kumalo is also complicit in the matter of censorship?
Manje musuzofaka izincwadi zakho kwa-DPP wakufaka yini nokuthi lo-Kelly Kumalo yathinteka kuleli cala?
My lord, yes, I presented all the evidence as it is, and as I indicated, part of my recommendation or request was that she should be charged, but then there were further instructions insofar as she is concerned at that stage, my lord.
Yebo, ngafaka konke kulezi ncwadi engazifaka kwa-DPP, and futhi ngasho-ke nokuthi naye ufanele athoswe icala.
And based on your investigation, you were satisfied that there were reasonable grounds to believe that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the matter of the G60.
Ukuthi wena-ke wawenelisekile ngokuthi-ke uyasoleka naye and futhi-ke wawukholwa ukuthi kufanele naye athoswe icala.
Yes, I was, my lord.
Yebo, kunjani.
Now, this is what the state told this court in terms of Section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. And I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial fact which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
Yes, it is the court, my lord. I think that is... It's a misdirection. It's a misrepresentation of fact. It can't be had to be said that, and I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial fact which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
Yebo,
and information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case? In my line of cross-examination, I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case. Then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid. I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case. Definitely.
Yes, Mr.
Well, I don't know what daring and the guilt refers to.
Maybe
but
let's read section 104.
yes. But such obnoxious comment notwithstanding, my lord, we submit that this witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. And we don't want to repeat ourselves, my lord, but we submit that that line of cross-examination should be disallowed.
As it please the court, madam. May I respond?
Hello?
I'm saying, may I respond?
No, you must address me on the law. Because you
That
say...
is what I'm saying, madam.
Also, you're saying?
I'm saying, may I respond?
Yes.
Yes. I think my colleague is running away from telling the court about what you read being a prejudice.
What?
Prejudice to the accused. These accused persons, my lords, have been arraigned to this court to answer the allegations that are contained in the summary of the substantial fact. And there is nowhere in the summary of the substantial fact where Kelly Khumalo is mentioned as a kingpin. Instead, in the summary of the substantial fact, Kelly is mentioned as a victim. Now, all along, throughout the testimony of Brigadier Gininda, Kelly Khumalo is branded as the kingpin, the person who organized the killing of the deceased, which is the reason why I am asking if at the very inception, at the drawing, at the preparation of the summary of the substantial facts, the state was aware that Kelly was a kingpin, so that when it decided to draw this summary of substantial fact, that should have been a factor to be taken into account, so that when these accused persons come and answer on the allegations that are against them, they know that amongst others, we are before this court to answer allegations that we were in consort. We worked together with Kelly Khumalo to assassinate Kelly Senzumiwa, and that is not there. They are now expected to answer on something that was initially not put to them at the beginning of the trial. Remember, my lord, when the charge is being put against this accused person, the summary of the substantial fact is also read into the record. That is part of the charge sheet. There is nowhere where they were called upon to come and answer that they worked together with Kelly Khumalo. That is the reason why I am basically asking, and I'm not trying to indict any person. I'm getting somewhere with this line of cross-examination as to whether or not at the preparation of this indictment was the state aware that Kelly Khumalo, without Kelly Khumalo, would not have been here basically. as per the testimony of Brigadier Kininda, we would not have been here. Because accused persons would not have had anyone to come. According to the allegations of Brigadier Kininda, these accused persons would not have had anyone to entice them to go and kill Senzo Meyiwa. But that is not contained in the summary of substantial fact. It doesn't matter, my lord, whether a person is charged or not charged, but the summary of substantial fact must contain the information that is contained in the case docket, so that when the accused persons are confronted with that allegation, they are able to respond accordingly. And that has not happened in this case, which is the reason why I am compelled to find out, because now they are expected in the middle of the trial to answer to something that has not been there at the inception of the trial. There's nothing wrong in me finding out whether or not at the time at which the decision was made, the state was already aware that Kelly Kumalo was a kingpin.
But you're arguing something different.
No, okay, my lord, let me hear. When the court says it's different, in what way, my lord?
Let's play your question first, because you're into the merits, etc.
No, I'm responding to the state, my lord.
What were you responding about the irrelevance of this witness being cross-examined on the content
Yes.
of the indictment,
Yes.
which, according to you, you're saying it's not relevant for this witness because it is the
Yes.
Director of Public Prosecution
Who
drafts
Yes.
the indictment, including even that panoply of facts.
Yes.
And that you also say that, but even that also doesn't bind the state.
Yes.
I thought that was what we were talking about.
Yes.
Now we're talking about Kelly Kumalo.
No, madam. The Director of Public Prosecution, yes, does draft an indictment, but is drafting an indictment based on what facts?
Then I find
Who brings the facts to them?
Mr. Yes, you can argue those facts. But if you read that act,
Yes.
it says in
The section.
It says in the opinion of the Director of Public Prosecution,
Yes.
not this witness.
That is correct, my lord. But now, if it is in the opinion of the Director of Public Prosecution,
Yes.
and the witness includes something which, in the opinion of the Director of Public Prosecution, has not been included here, must we then fold our arms and say no? Because the Director of Public Prosecution has decided not to include this, we should also not take this witness on
Then
that evidence.
you should have requested further particulars.
But we did
No, that's the procedure.
Yes.
Am I correct, sir?
Yes.
Otherwise, we'll be here the whole day. When you are hit with, you're trying to serve with an indictment,
Yes.
you've got a right to request further particulars and further and better particulars. Did you do that, sir?
Let me respond, madam.
Yes.
Yes.
Yeah, fine.
There is no way where in the indictment it is mentioned that Kelly Kumalo is a kingpin. Had that been mentioned from the onset, we'll definitely have requested further particulars. There is nowhere in the indictment where it is mentioned that Kelly Kumalo is a suspect. Instead, in the indictment, it is specifically mentioned that Kelly Kumalo is a witness. How could we then have been enabled to request further particulars when we did not know that Kelly Kumalo, in the mind of the investigating officer, Kelly Kumalo is a kingpin?
But Kelly Kumalo,
Yes.
Kelly Kumalo is not charged in this court. I don't see it.
Yes, she is not charged, my
Yeah,
lord, by
so
the fact
why should I respond to that? I only respond to persons who are charged.
that is correct.
Whereas litis contestatio
Yes.
between the accused and the state.
Yes,
Kelly Kumalo, I don't know.
Yes, my lord. Her not having been charged, my lord,
Yeah, you can argue that.
it's not a
Ask that very question to this witness. Every question you want to ask him, ask him. To prove that the law was complied with when the statement was made.
Yes,
To be a sworn statement.
Correct.
Okay, right, you can proceed.
thank you. Sir, Brigadier Kininda, is it correct that you are the deponent of the statement A227?
That is correct, my lord. Kuyiqiniso ukuthi wena obhale lesi statement ukuthi yebo iqiniso.
Is it correct that you actually read this? Sorry, you're the one who wrote the statement by yourself.
That is correct, my lord. We osibhale ngokwakho ukuthi yebo yimi.
So did you read back the statement to the satisfaction of the contents that are contained therein?
No, I made a statement, my lord. It's my statement. I made it.
Usifundile le statement ngemva kokuthi usibhale uthi mina yimina ongisibhalile bekungenasidingo sokuthi ngisifune.
Did you sign the statement?
Correct, my lord.
Usayinile uthi yebo ngisayinile.
In the presence of the Commissioner of Oath?
That is correct, my lord.
Usayine ngaphambi komuntu obekade esikhiciza istembu uthi yebo.
Is the statement binding in your conscience?
That is correct, my lord.
Leso statement isiphethene isihlangabezane nonembeza wakho uthi yebo.
So do you correct the truthfulness of that statement?
Yes, I do, my lord.
Leso statement isiyiqiniso uthi yebo.
The date in which you signed the statement?
It was 20 November 2020, my lord.
Usayine nini uthi nge-20 zika November 2020.
Thank you, my lord. I take leave for the witness to read the statement on record.
Okay, sir.
Cela ukuthi asifunde uyafunda ke uBrigadier Kininda.
Lord, it is as follows. I, the undersigned Bongani Nicholas Kininda, state under oath as follows in English. I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I am currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit of the National Commissioner with the rank of a colonel. I've mentioned the service number, my lord, and the telephone number, which I would like to skip. Paragraph 2, I am the lead investigating officer of Phosphorus Case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 2030 and 2100 hours. This deceased was shot at the house belonging to then his girlfriend, namely Kemi Kumalo. It initially appeared that it was a robbery gone wrong. Witness statement under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery gone wrong. In this confession, he clearly implicates Ms. Kelly Kumalo as the person who gave them the instruction to kill Senzo Meyiwa. Photos were equally found of the murder weapon used in the murder of Senzo Meyiwa, a photo containing the exact bag of money similar to the one found in Ms. Kelly Kumalo's. Ms. Kelly Kumalo was found. Kelly Kumalo, 3.6, Nonhlanhla Kelly Kumalo. 4 cell phone numbers that she did not disclose to the police when this incident took place. These numbers were discovered by the XDS system used by the cell phone analyst and subsequently linked to her activities. The numbers are as follows: 079-494-4358, 073-451-5017, 073-886730, 061-456-2108. Investigation further revealed that she is linked to the actual perpetrators of this murder by means of cell phone linkages. These linkages connect her to accused 3 and 5. It was further discovered that through cell phone analysis, her cell phone memory album has the same photo of a see-through bag containing cash, notes, and in the exact position or location or spot of that of accused number 3. There is no reasonable explanation as to why Kelly Kumalo will be in contact telephonically with the headman or killers of a boyfriend and share the same picture of a bag full of money. Communication records between her and her sister shows that as early as 2013, she wanted to get rid of the deceased, as she puts it. It is apparently clear that she hated him and wanted to get rid of him. She further states that she regrets not succeeding to get rid of him before. Taking into account all these facts, an inference can be drawn that she meant killing him. Cell phone record shows that after the incident took place, she phoned a number of people from 082-703-4358 number but no call was made to emergency services. She also subsequently went to the witch doctor for cleansing, as was also done by the other accused in this matter. The statement of Mr. Mkhize, who is an expert in these matters, clearly indicates that this is normally or how it, this is not normally or how it should be done, especially if one is innocent.
All right, we can start this.
The court, please. All the accused are now here, my lord.
Okay.
I think Advocate MNISI would like to address the court.
Yes, Mr. MNISI, you are at the word.
As it is the court, my lord. The court will recall that as we went for recess, there was a suggestion that we reconvene today in order to come confirm what is the situation with regard to Mr. Sibiya's representation or the status of his representation. I may indicate, my lord, that I have been approached and requested to assist Mr. Sibiya in the conduct of his defense, which request I have acceded to. However, there are still some final details that need to be finalized with regard to the paperwork, because as of now, there's literally nothing that I can start to do with regard to consultation with Mr. Mncube on the matter, because I don't have the power of attorney as yet. However, I may say that in principle, henceforth, I will be assisting Mr. Mncube with the conduct, with Mr. Sibiya. I'll be assisting Mr. Sibiya with the conduct of his defense, such that I think the position would have been sorted out and finalized on the 20th, which will be the date on which the first recess of 2025 would then be commencing, my lord. I've spoken to him and informed him of the situation. He seems to be understanding, but it can only be fair if the court were to confer with him, my lord. Thank you, my lord.
Yeah, Ms. Replica.
Mr. Court, please. Ke njengoba bekuchaziwe ngaphambilini uyachaza manje ubaba uMNISI ukuthi uceliwe ukuthi akasize ubaba uSibiya ngokuthi ke amsize la enkantolo, kodwa ke usathi ke uzazama ukuthi asilungisele ukuthi malifika usuku lwamhla ka-20 akwazi ukuqhubekela phambili nokuthi akumele. Manje ke asazi ke baba uSibiya ukuthi uyizwisisile. Understood, my lord.
Yeah, but have you consulted with the advocate MNISI?
Ukhulumisanile yini no baba uMNISI phakathi? Yes, I did.
Where was the consultation?
Manje benikhulumeni laphi? We spoke to each other right here in court.
Okay. So you have at least given him instructions to represent you.
Ushuthi wena ke ushuthi umcelile ukuthi akube uyena ozokumela. That is correct, my lord.
And your parents, have you notified them of that arrangement?
Ubazisile abazali bakho ngaleyo malungiselelo. That is correct, my lord.
Are you agreeable and are they also agreeable that you should be, from henceforth, be represented by advocates MNISI?
Manje wena uyathokoza yini nabo bayathokoza yini ngokuthi ubaba uMNISI kube uyena ozoqhubekela phambili ngokumela? That is correct.
Okay, fine. Yeah, and the other thing, Mr. MNISI, sorry. I suggested to him that maybe, it's not an instruction, it's a suggestion, that the late colleague of ours, Mr. Ngomezulu's notes, if they are still available, you can have recourse to them and also use them to consult with you concerning those notes. Is that okay, sir? I'm not saying you must use them, I'm just saying it may be that he has made notes and he has taken instructions which you may not be aware of, and when you go through these notes, you may come across certain notes or instructions which you can check with Mr. Sibisi.
Mr. Spear.
I mean, Sibiya.
Yes, madam. No, thank you very much for that opportunity, madam. Definitely, I will liaise with Mr. Mgomezulu's family and find out if that information is still available. And if it is still available, and request that it be made available to me so that as I consult with Mr. Sibiya, I go through that as well, madam.
Okay.
And thank you very much for the
Thanks.
Thank you.
Yeah, in the meantime, then this matter will again be postponed to the 20th, on which day, hopefully, Ms. Mshololo will continue with the cross-examination of Colonel Kininda. Is Kininda aware of that?
Yes, indeed, my lord, and he has made himself
Available. Right? And after that cross-examination, then Mr. MNISI will revisit the cross-examination which he wanted to take Brigadier Kininda on regarding some documents. Am I correct, sir?
That's correct, madam.
Right, and thereafter, if Mr. MNISI is ready, after having consulted extensively with Mr. Sibiya, then he, Mr. MNISI, will start with the cross-examination of Mr. Sibiya, accused number 1. Is that so?
That is so, madam.
Okay.
Family, was it a right choice for MNISI to stand for accused number 1? Did accused number 1 made a good choice? My answer to that is yes. However, I would have loved to see the lady who helped accused number 3, Advocate MNISI's client, the solitary confinement. I would have loved to see that lady standing for accused number 1. Why I think like that? Do I think MNISI is not strong enough? He's not bold enough? The answer is no. MNISI is bold enough and he can stand at any weather. It doesn't matter who you are, because MNISI, what is good about him, when he asked a question from the state witnesses, more especially from Kininda, he doesn't move an inch if he is not answered to his satisfactory. I think MNISI has gained so much confidence to even confront the judge when the judge tries to be biased or tries to side with the state. These clips that I've put here, they show the boldness of Advocate MNISI, that he can stand any weather. He doesn't care whoever you think you are, as long as he is in the right side of the law. He stands tall, he stands his ground, he's never shaken, which is a good thing. When you have your client and you want to prove that you can stand bold when you know that you are in the right side for your client. Those are kind of things that have to be uploaded from such lawyers like Advocate MNISI, Advocate Mshololo, and the other advocates. Because what they should understand as lawyers, as advocates, it's when they tackle a certain issue, they are in a market, a big market. They are marketing themselves, more special for them. The footage is there. They are being watched around the world. All the proceedings that are going on there. There are people who will feel like, I wish I can get that lawyer because they have seen the good work of the lawyer. We cheer them because we see how they operate. We are not saying MNISI is the best of the best within those lawyers. These lawyers work collaboratively. They collaborate. Because one will start the case and they take notes. Wherever one misstep, they will come and foot that one. Because it's a chain of lawyers on one case. There are 5 lawyers. Ramsipile started, and Advocate MNISI came for accused number 2. Ramsipile, because it was supposed to be Mgomezulu, but Mgomezulu fell sick when Ramsipile was the first. Then came Advocate MNISI, then Ngumalo. On the 20th, we are going to be seeing Mshololo doing what she is capable of doing. We love her. She is our queen. She does the best when she take on the podium and start doing her job the best she know how. It's amazing to see women stand up for men who are bully. Because sometimes Mshololo has a lot of pressure that comes from that big chair. But she inhaled that as a woman. Because women, they go through a lot. But she still carry on the mandate for her client. So, do I really support Advocate MNISI take on client number one, which is accused number one? I support MNISI. I know he will do his best. But what I did not like yesterday, it's when Ratha talk about people who feel they were wrongly convicted. And he talked about that while he is proceeding with the Senzomeyiwa sensitive case. What message exactly was Ratha sending to us? Was he telling us that he is going to convict these people? And even if they will apply for appeal, it will be after a long time. That's why he gave an approximately that people who have done that, they did it after 12 years. And at some point, they decide to abandon the appeal. Was he supposed to say that statement in court? The answer is no. Because it brings a million questions up to now that are not answered as to why he brought this kind of circus in court. Because this was not called for, but he decided to bring it up. What do you think, family, about that? Please drop your comment respectfully. Don't forget to like, share, and subscribe. Let's keep the candle burning until the Miwa family get closure as to how their son was deleted. We are in 2025. We hope for the best. We have to carry on the fight. Bravo, bravo, bravo.